And by and large, if you just read the entire statute in general, it's an enforcement statute. There's no conferring a private citizen of the right to seek the type of demolition that a private citizen.
Would you agree that in housing court, in a proceeding initiated by the city, housing court would have authority to order demolition at the city's request?
Yes, and then there's a couple different avenues in which that could happen. There's also the preservation ordinance that allows the emergency demolition of historical buildings, but brought by the city of Buffalo themselves. There's also the general demolition ordinance in the city of Buffalo that would allow for emergency demolition.
So the question here is who's asking? If the city asks yes, if it's the property owner, no.
That's our position. And when you take a step back and you try to separate the forest from the trees, there's a lot of work that needs to be done before you demolish a building of this type of nature. And the Buffalo City ordinance provides that a building permit needs to be sought. And in order to get that building permit, you need to do a lot of things, right? You need to get asbestos testing done. If asbestos abatement needs to be done, that needs to be shored up ahead of time. You need to cut off the lines to the gas, the electric. You have to cap the sewer. You have to look at dust mitigation and how are you going to protect the surrounding buildings. There's a lot of work that goes into obviously demolishing a building. And when you have a building of an historical nature, like here, you want to have that added level of review. You want the preservation board to weigh in. For whatever reason, Mr. Carr did not want to engage in that process, want to sidestep it, go right to Buffalo State Housing Court. So we believe that he is wrong, both procedurally and on the merits.
Well, thank you, Councilor.
Thank you.
We're now going to call case number 640, People versus Richard Ubanwa. 640 Ubanwa. Both counselors are remote for number 640. We have Mr. Keem. Ms. Hellenbeck. Mr. Keem, you may proceed.
Good morning. May it please the court. My name is Brad Keem and I represent Richard Ubanwa. We assert Mr. Ubanwa was denied the meaningful representation of counsel. First, defense counsel acted in a confrontational manner with Mr. Ubanwa regarding whether he wanted to testify at grand jury. The briefs contain a transcript of the interaction, but what struck me was that defense counsel just demanded a yes or no answer so many times when Richard was so obviously uncomfortable and confused.
Counsel?
Yes.
Sometimes we see that when an attorney is trying to keep a client from incriminating themselves. And the client might have a tendency to run a little long sometimes in terms of describing things. And so the attorney will interrupt and say, no, just yes or no, just yes or no, to try to limit that. Why shouldn't we view the record in that light?
Well, I think that defense counsel could have done so many other things. If that was the concern, then defense counsel could have asked for an adjournment. He could have stopped Mr. Ubanwa, explained the options on the record about the grand jury. He could have told the trial court that he was having a difficult time communicating with Mr. Ubanwa and then leave it to the trial court to then act. I think that because we're talking, I think it was like 7 or 8 times that he's saying yes or no, Richard, yes or no, Richard, when he is struggling. I mean, he's falling here. I found that to be less than meaningful and lacking any legitimate explanation when so many other options were available. Secondly, the immigration consequences. So eventually he agrees to plead guilty, but Mr. Ubanwa says upon inquiry by the trial court that he couldn't fully talk to defense counsel or an immigration attorney. And the record and the briefs reflect what happened with the first immigration attorney. And then defense counsel says, yesterday afternoon, I spoke with an immigration attorney. But it's really defense counsel's responsibility to have informed Richard and for Richard to have felt, Mr. Ubanwa, for him to have felt comfortable with that situation. And in my reading of the record, and I know that there's a possibility of an off the record argument as well, but I think enough is on the record to demonstrate that Mr. Ubanwa did not really understand what the immigration consequences were, and that was
right. And let me ask you this. Your client was not a citizen when he pled. He came here to go to college. He went to SUNY Oswego. He overstayed, his visa expired, and he stayed. Has he been deported since this conviction? He got a misdemeanor. He got pled down to a misdemeanor from felonies. Has he been deported?
No, I've spoken with him. He has not been deported.
Right. So what would he have if he could go back in time, knowing what he knows now? Wouldn't he be all the more willing to plead? He hasn't been deported. Usually these deportation consequences, oh, I pled guilty. I didn't realize I was going to be deported as a result of my plea. Your client pleads down to a misdemeanor and he's still here.
He
So
can't get,
to make of that.
He can't be a citizen right now because of the sex offense. At least that's his understanding and what he's been discussing with me.
Right, so it's not that he's going to be deported. It's that the path to citizenship is going to be rougher or impossible for him now because of this.
Yes, and certainly the world we live in is different than other times, and immigration is quite an issue these days. And having this conviction is something that he.
Right. So don't we need to know that when he pled guilty, he was under the misapprehension that it was going to be smooth sailing on citizenship if he pled? Like, well, I think that's why there's a motion. Like you bring a motion and say, my lawyer's ineffective because he told me I'm going to plead to a misdemeanor. It's going to be no problems. I won't be deported. No problem if I want to be a citizen. And now there is a problem. So, but we don't know that anyone said that to him. We don't know what his mindset was when he pled. And that's why, I mean, one option here would be, I'm not saying he doesn't have a claim, but perhaps it's through a motion under CPL 440.
And I acknowledge that there is possibly a 440 motion that lies, but I thought that the direct appeal was clear enough that the communication here was not present, and that alone would constitute ineffective assistance of counsel that would be worthy of vacating the plea and sending it back, because it just doesn't seem as though on the record there's an indication that communication was occurring here such that Mr. Ubanwa understood the consequences of the plea on his immigration status.
But counsel, in terms of the obligation of defense counsel, not immigration counsel, but defense counsel, you cited Padilla versus Kentucky in your brief. So you have the quote, need to do no more. The defense counsel need do no more than advise the non-citizen client that pending criminal charges may carry a risk of adverse immigration consequences. I mean, wasn't that clearly communicated?
Again, when Mr. Ubanwa says that he couldn't fully talk to, and that was his quote, and it wasn't really elaborated upon because defense counsel takes a position adverse to that and says, I spoke to immigration counsel yesterday afternoon. Well, to me, that's not really meaningful representation at all to go opposite of what Mr. Ubanwa is saying, or to at least suss it out, to provide more insight as to what he means when he said he couldn't fully talk to counsel.
Right. Well, it seemed like the problem here was that the case had been pending for 3 years. And the judge and the prosecutor hadn't even submitted to the grand jury if this is the right case I'm thinking about.
Yes, it is. Yes.
So the judge said, look, I don't have any control over the DA. The DA wants to indict. He's been waiting 3 years in local court. And in their view, 3 years was enough time for him to get the advice that he needed to get to decide whether to plead a very favorable plea with 2 different alleged victims, an admission here. I think most people would look at defense counsel's performance as favorable, getting a favorable result here, down to a misdemeanor, minimal jail time, and so forth. Yet you're saying he was defective in his representation because he didn't forecast future citizenship problems, I guess, is what the argument is.
It is based on, my discussions with Mr. Ubanwa and how he feels initially there was an offer that didn't go through for interim probation. I'm making the arguments that I think are supported by the record and what my counsel or what my client desires.
I understand.
But unless the court has questions on the other issues that we raise, I'll rely on my brief.
Thank you, Mr. King. Hollenbeck.
Good morning, Your Honor. Amy Hollenbeck on behalf of the people. Our position is that counsel was not ineffective, and that the record actually demonstrates that he spent a lot of time on the immigration issue in discussions with the court, in particular about what the direction that the case was going to take. The record reflects that the misdemeanor plea was crafted in coordination with the immigration attorney, defense attorney, and the people to provide one of two. He could choose between one of two misdemeanors, whichever one fit. He had been in jail for about a year before he was released on this case. I don't know how many months, approximately 6 months before he entered the plea. I don't recall the dates. And nonetheless, they agreed to a 5-month sentence as opposed to a 10 or 12-month sentence. I don't practice immigration law, but I would assume that was also done in coordination with immigration counsel, essentially to give him the best offer that was acceptable to the people in the court, while also giving him the opportunity to protect his immigration status as well as he could if he chose to accept that offer. And in regard to the discussion about testifying for grand jury and the defense attorney's approach to him, I think the record also reflects that the court was trying to get an answer out of him because he had been transported from Buffalo detention to Oswego County Jail, not for the purpose of the plea, but for the purpose of testifying at grand jury because he said he wanted to. Then when he got there, he changed his mind and said, I don't want to anymore. And both the court and defense counsel were just trying to get a simple answer. Do we need to bring you over to the courthouse upstairs from the jail to the grand jury room tomorrow morning, or don't we? And it wasn't counsel pushing him to plead. Counsel wasn't saying, yes or no, are you going to plead? Counsel was saying, yes or no, do you intend to testify? And when they walked out of the court that day, he said yes. And the plan was for him to testify. So I don't think that anything that counsel did there interfered with his fundamental rights or coerced a plea. The plea came the next day, but when they left that day after that discussion, his intent, as he expressed it to the court, was to plead. I would submit that he clearly said he wanted to talk to a third immigration attorney. But I don't see, as pointed out by the court, we're not talking about immigration attorneys' effectiveness here. We're talking about defense counsel's effectiveness. Defense counsel had talked to the immigration attorney. The defendant confirmed that he had talked to the immigration attorney before he chose to take a favorable guilty plea in light of his admission and the reduction from a felony to a misdemeanor, no additional jail time. I would submit to the court that counsel was effective, and there's nothing about the record that indicates that the plea was in any way anything other than knowing, intelligent, and voluntary.
Thank you.
Thank you.
We'll call, case 641 is People versus Christopher Freeman, 641. Mr. Greenberg, good morning. You may proceed.
Good morning, Your Honor. Are you able to see me? Did I log in correctly?
I'm sorry?
Yep.
Are you able to see me?
Yes,
Oh,
we are.
good. Okay. All right, thank you. I'm representing Christopher Freeman in his appeal from the Seneca County Courts. And in reviewing my notes, I think the substance of point 1 can be argued simultaneously with the branch of point 2 about the voluntariness of the plea and whether he was competent to enter the plea on a voluntary basis. Because when I reviewed the record, there's numerous points during the plea where he states that he has a very limited education. I think he only went as far as the 12th grade, and he also has cognitive issues. He was in special education classes, and that he didn't really understand what was going on in the courtroom. And I think that is relating that to point two, is that maybe the trial lawyer should have referred to some kind of a competency exam to see what was going on with him. Because I was very concerned with didn't really understand it. The plea itself seemed to be very unusually coercive, with the judge stating on numerous occasions, it has to be voluntary, and the top charge, I believe, was attempted murder in the second degree, and that can carry.
He was answering questions appropriately, though, wasn't he?
He was answering questions maybe appropriately in the technical sense of the word appropriate, but it seemed very guarded and it was always seemed to be punctuated with that he didn't really understand what was going on. And his Mr. Zimmerman, the trial lawyer, all the time seemed to be coaching him as to what to be saying. So I mean, that's why I think that when you relate, is it truly a voluntary plea in relation to the lack of the competency exams? And I think that maybe that for that point alone, it should be reversed and remanded for for further proceedings on. Yes.
Counsel, I appreciate that before he entered the plea, really the factual part of the plea, he talked about, again, limited education and special education, that kind of thing. And then after he had entered the plea, he mentioned that his attorney just told him to say yes. That's a quote that you mentioned in your brief as well. So we have it both before and after this, elements of confusion. What I'd like to ask you about the one part that concerned me, I'd like to narrow in a little bit. And that's during the factual colloquy itself.
Right.
The judge asked essentially the factual question: Did you stab the victim? Did you intend to do it? Did it cause serious injury? All really in one question. And that's where you, I think, in your brief noted that at first he said no, then he said I don't know, then he said yes, and then the judge sort of backed off and said, "Look, I can't accept this." So the judge acknowledged that we've got a little bit of a mess here in terms of factually. My question is what the judge did next. It seems to me from my reading is that the judge has a duty to further inquire under, a series of case laws, but certainly starting with People v. Lopez. You have a duty to further inquire at that point as to whatever the nature of the confusion is. But my review of the record is that instead the judge takes a break. He talks to his attorney. Maybe the attorney further inquired in the hallway. I mean, we have no idea. It's all off the record. When they come back, the judge asks the same question again. And it was a 59-word question. It was a long compound, and it's okay for the judge to ask a long question, but it's the same question. Is that in your mind further inquiry under Lopez, or does the judge have to do more? Is the judge required to ask different questions for something different, or can you just ask? Can you just ask the same question?
Oh, I think you honed right on my concern, Justice Novak, because I think it can't just be repeating the same questions. I mean, I think what Lopez and his progeny had in mind was more, okay, if you don't understand, is there something specific that you're not understanding? How does the special education classes affect your ability to understand more complicated things like taking a plea to court and things like that? I mean, you can't just, and I have no idea what went on obviously outside in the hallway, because that's not recorded. But
isn't that relevant to like that really should be a 440 based on what you just said?
Well, I mean, I think if you want to raise the issue of something that was truly off the record, that would be appropriate for a 440 motion. But I think what is on the record is the judge's failure to do that searching inquiry as to whether that's clearly is on the record, as Justice Nowak just pointed out, with the 59-word question that basically repeats what was already said. And that's why, and I think that there should have been some kind of an inquiry beyond that. So.
Right. Look, I would say this. This plea is bad. This is a bad plea. Is it Lopez bad, though? Is it Lopez bad? Lopez requires something the defendant says that clearly casts significant doubt upon the defendant's guilt or calls into question the voluntariness of the plea. Clearly casts significant doubt. I would say here, yeah, there's a little doubt maybe, but I don't know if it's quite Lopez bad, such that because your contention is not preserved. So it's not just whether the plea was sufficient or not. It's whether it's one of these that's so obviously bad that no motion needed to be made, and we can address it on appeal for the first time.
Well, I would.
I don't know. That's where it gets closer.
Right. Well, I mean, my argument would be is that, as you just said, it truly is a bad plea. I mean, he's all over the place on where he, on understanding what's going on. And as you point out, he does say initially, did you do the crime? And his initial answer was no. So, I mean, I think that alone.
Right. Well,
that
if
alone,
obviously, if Judge Porsche has left it at that, we have a Lopez problem.
right.
But Judge Lopez or Judge Porsche did not leave it at that. He recognized there was a problem with the allocution, that the defendant couldn't admit certain elements. So he said, not unreasonably, look, I can't take a plea if you're not guilty. We're going to schedule this case for trial. Nothing wrong so far, right?
That's correct. I had stopped there.
And then he gives the lawyer and the defendant a break so they can chat in private. Nothing wrong there. Matter of fact, good there, right? That's a good thing to do. So far. So you're with me so far. Everything's good. Then they come back into court and Judge Porsche asks the question again, this triple compound question, not the greatest question. I wouldn't have done it that way. Same question he asked essentially before, and then he gets the yes answer.
Right.
So the question really is, Judge Nowak has identified it, is that repeating that question a sufficient inquiry here? Now he does add, the judge does add one additional question that says, Mr. Freeman, are you telling me the truth when you answered that question? So there was a little follow-up there, but that's really what it boils down to is asking the same exact question again and getting a different answer. Is that sufficient is that a sufficient inquiry?
No, I would argue certainly not, because what has already been placed on the record is his limited education and the fact that he had the special education classes and they only went as far as the 12th grade. So, I mean, I think at that point, Justice Porsche should have been asking a different set of questions and not just simply reiterating what had already gone. Like, for example, maybe a good follow-up, and this is just speculation on my part, because I mean, I wasn't the judge, or there or anywhere for that matter. But I mean, I think that a good follow-up might have been after they came back from outside in the hallway, might be to start asking questions like, well, would you put on the record what the nature of the special disability was, what was the nature of the special education, and that, do you understand, fully what was transpiring, and the questions along in that vein.
Look, I think it's even more basic. He could have asked, did you stab her? Let's start with that. Did you stab her?
Yeah.
Okay.
Well, that would be
no, then we're going to trial. If it's yes, well, did you intend to cause injury to her or serious injury to her by stabbing her? Yes or no? If so, do you dispute that she sustains? I mean, that's how you do it. You break it down in fights and walk the defendant through it, not all of them together. But again, it's a question of whether the Lopez exception is going to apply here.
Right.
That's what we have to look at.
Okay.
The last thing I just want to ask to follow up on Justice Lindley's question is with respect to what happened after, after that long question, it looks to me from the record that for the next 2 pages, all we have are one-word answers from the defendant.
Right.
Yes,
right.
Yeah, guilty. Those are his answers. And then after 2 pages, and there's a question about the pre-sentence investigation that fathered the defendant, and the defendant says, wait. And then he says, he lied to me, referring to his attorney. And then following page, he said, he just told me to say yes.
Mm.
So does that in your mind affect sort of what those one-word answers on the previous 2 pages?
Well, I'm always suspicious of one-word answers, even as a general principle, because it sounds like yes, 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 yes. I think, defendants should say something beyond that. But as applied to this specific case, yes. I mean, I think that just makes the bad plea even worse because now he's turning the tables and saying that, oh, the lawyer told me to do this. No, so that I think is kind of like is seals the Lopez exception, and then why you, as the appellate division, can review this issue without reference to a 440 motion. So I don't know if that answers your question, but I mean, but I would agree. I would agree that made it ever more disturbing. So in my mind, this entire plea should be sent back.
Thank you, counsel.
Oh, and the only other element I just want to mention in the second branch of the ineffective assistance of counsel was the fact that one of the discovered documents indicated that he was on also a drug. I don't know what the name of it was offhand. I really some kind of a psychotic drug or whatever at the time.
Yeah, it's in your brief there. I can't even pronounce it. So
yeah, it's benzodiazepine. He was on that. There was indication that he was under the influence of that when the crime occurred. So that I think would also go to whether even if he had stabbed her, did he stab her with the intent, with the requisite intent to do her harm? I mean, if he was under the influence of this drug. So.
yeah, we understand that point. So thank you very much.
Okay, thank you, Your Honor.
Case number 644 is Anderson versus Knotts.
Good morning, Your Honors. Cleo Weiss for the mother. I'd like to just focus on the issue that I believe there is an insufficient record for this court to review on this appeal. As was briefed in my brief and the AFC's brief, there's been a subsequent neglect proceeding against the petitioner who is a non-parent. And I think we have two really uncommon things. One, a non-parent petitioning for custody of someone else's children, and two, the government making allegations that somebody is unfit to be a parent. That's not very common statistically. And I think the family court judge in this case, there needs to be a remittal so the family court judge can consider why the government thinks that the non-parent petitioner is insufficient, is a neglectful parent. I think
Didn't that result in an ACD against the godmother, the petitioner here?
I want to defer to the AFC for the Michael B update in terms of what's going on with those proceedings.
This is the proceeding you're referring to. You're saying in light of this new allegation, it should be remitted for emergency hearing, a new hearing on information that postdated this case.
And I think that regardless of the result, what has resulted in that neglect proceeding, the allegations alone that the government felt it necessary to file a petition against Ms. Anderson, those allegations alone should be part of the best interest inquiry in this case.
What if the petition there, the neglect petition, was dismissed against the petitioner?
Even if it was dismissed, I would still ask for remittal so that the family court judge in this case can consider what those allegations were. What we do know in this record is that there was the indicated CPS report, whether it is the same event that led to the indicated CPS report that also led to the further neglect, or whether there was a second set of circumstances that led to the neglect report. I think the family court judge must consider that because extraordinary circumstances in this case with a non-parent petitioner overcoming the preference for biological parents, that's a very high bar. And I think it's almost the opposite. A neglect petition is almost the opposite of demonstrating extraordinary circumstances so as to come in and divest a biological parent.
The same judge? It's Judge Mazzo in both cases.
I believe that's correct, but I will defer to the AFC.
Yeah, it's definitely, I have the record right here. Okay, Judge Mazzo's ACD. So she did hear it already.
But it postdated the judge's decision in this case. So what we'd be asking is for a remittal to allow that judge to reconsider this in light of the later neglect.
Do you have any information about, or do you want to refer the AFC on this also? The mother's in Kentucky, right?
Florida is what I believe.
Now she's in Florida.
I believe she's always been in Florida.
She was in Florida. I'm sorry. But is there another proceeding going on also? No, in another state or anything?
I don't believe there's any proceedings in Florida. I would certainly, as an attorney, wouldn't be party to those proceedings.
I just.
But we could do a Michael B. remittal for a new, fresh, extraordinary circumstances determination is what you're asking for. Or could not the mother, your client, just file a modification petition, say change in circumstances? Look, she's been indicated by CPS. There's two ways to get to that same point.
So I think the two ways are not the same. And the reason they're not the same is that a modification petition, the mother would be on equal footing with Miss Anderson at this point, whereas in the extraordinary circumstances inquiry, it's Miss Anderson's burden to overcome the preference for biological parents. Right. When on a modification petition, which of course my client could bring, she's now just equal to this non-biological parent.
Are you aware Michael B. was a best interest case? Court of Appeals allowed for that to happen, to remit in light of new circumstances under best interest. Are you aware of any cases that apply Michael B. to extraordinary circumstances, which is a different analysis, of course?
It is, Your Honor. Off the top of my head, I'm not aware, but I would ask Your Honor for permission to file a post-argument submission on that point.
I'm curious on that. The principle makes sense. If we can remit for best interest, why wouldn't we? But I'm just curious whether there's a case law on that.
Yeah, I'll certainly follow up with the court as to any Michael B. remittals in that specific procedural context. But why I think it would be appropriate, whether it's happened before or not, why I think it's appropriate is that the extraordinary circumstances inquiry is typically looking into the biological parent's unfitness, showing that the biological unparent is unfit and therefore this non-parent is coming in and showing extraordinary circumstances. But here we have the exact opposite. We have the non-parent petitioner we have some indications that she is not fit. And that's why I think we need the removal on that.
I understand. Anything further?
No, Your Honor, I'll rest on the brief for point 2. Thank you.
Thank you.
Please the court. Maureen Poland from the Legal Aid Society of Rochester for the Children. Just as a brief update, my clients do remain with the petitioner respondent. I went to visit them at her home last week. They are doing well. It's where they want to remain. I do think it is notable that despite a neglect petition being brought against the petitioner respondent, the children have remained in her care, but for a single night in foster care, and that the family court did conduct a Family Court Act Section 1027 hearing where it heard testimony from the caseworker, from the petitioner respondent in this matter, about what had transpired and chose to return the children.
It sounds like, am I correct to understand the proceedings that postdated this determination? In our case, the godmother, your client, went to the hospital. She had some emergency medical situation. She was at Strong. While she was in the hospital, the kids went with another daughter, with a daughter, and harm befell the children in the daughter's care, allegedly. And that's what led CPS to file the petition against your client. Is that generally correct?
So the petitioner respondent is not my client to represent the children.
I'm sorry.
But yeah. My understanding is correct that any alleged harm that occurred was not perpetrated by the petitioner respondent, I'll call her Ms. A, because we are talking about neglect proceedings, even if that's not the actual appeal here. She is not alleged to have engaged in any excessive corporal punishment or anything of that nature. It was a third party.
The teeth, there seemed to be some concerning information about rotted teeth and having teeth removed at such a young age and sugary drinks. That would have occurred on the petitioner's watch, no?
It certainly did, and not to minimize that, but that was with the youngest child, and the respondent appellant here dropped that child off to Ms. A when the child was a month old and didn't even leave the airport. Gave the child to the petitioner respondent here and got back on a plane and returned to Florida. Didn't even leave the airport to see her other 2 children who were in the care.
I think she was on probation, wasn't even supposed to be up here, I think.
At one point during the pendency of the case, correct. She was on probation in Florida for stabbing the children's father, and she was arrested while in Rochester and returned to Florida due to that probation violation.
You don't know her current probation status, do you?
I do not know her current probation status. I believe the testimony that she gave was that her probation ran until July 14th of 2024, but I don't know if there's anything subsequent to that.
So you would oppose a remittal on Michael B. You say these new allegations have been vetted, no reason for us to remit.
That is correct. I submit that this has been before the same family court judge. Certainly, the respondent appellant she participated in the neglect proceedings at least twice, was advised of her right to have counsel. As a non-respondent parent, she was certainly entitled to assignment of counsel and to participate in those proceedings, to argue as part of the neglect why the children should be returned to her, because for her allegations, Ms. A is not a fit custodian, but she didn't do those things. We have children who have at this point been with the petitioner respondent, Ms. A. The oldest child, S, has been there approximately 6 years. The middle child, S, has been there approximately 3 to 4 years. And the youngest child, whose first initial is K, has been there for 5 years. K has known no other home other than Ms. A's home.
So it was godmother, obviously, who is a petitioner. But my next question is, does mom have any access by her mom?
She's supposed to, but my understanding from speaking with godmother is that she does not utilize it, that it's been what Ms. A told me, what godmom told me last week, it's been at least 6 months or more since mom reached out to the children. And she's not blocked or anything like that to my knowledge.
Thank you.
Thank you, Counselor.
Thank you.
We will call case 645 is Hart versus Lonneville, 645.
This was the
Good morning.
That's my own.
We are waiting for Mr. Greenberg to appear virtually. And there he is for a return appearance.
Yes, thank you, Your Honor. I'm representing Stacy in this, Stacy Lonneville in this. This was actually a relocation matter. My first argument was that the failure to include the prior order should not preclude meaningful appellate review, because the contents of the order is reflected in other documents in the brief. So unless there's any questions on that issue, I'm sorry, in the record on appeal, because this is not the type of a case where you have to, do a forensic review of finances going back how many decades, like in a divorce matter, like I cited in Mergel and Patel. So unless there's any other questions, I can go directly to the relocation matter, and the argument for the relocation is that when you apply tropea, Mr. Hart did not present evidence of an adequate weight for relocating Alexander to Kentucky. It's been brought to my attention that the correct standard for that, evidence of an adequate weight may be more suitable for a criminal analysis, but some people suggested that it should be phrased as a sound and a substantial basis in the record. But I would suggest that that's actually basically reformulating the same standard with different words. But that being said, our argument is that he did not, that the tropea's when applying tropea to this matter, he did not present sufficient evidence to support the relocation to Kentucky.
Counsel, there were a couple factors that appeared to weigh pretty heavily in favor of the father. Certainly the economic situation for the child. Father, I think, made 5 times what the mother earned. And we have the child's living arrangements with the mother being almost to the point of dangerous. I mean, it's certainly suspect, but more than that's minimizing it. And then we also have this idea of feasibility of preserving the relationship between the non-custodial parent and the child. It seemed that mother did not dispute that she took steps to deny the father contact and information concerning the child. So do you agree that at least those 2 factors, tropea factors, would weigh in favor of the father?
Well, I mean, almost, I would not necessarily agree, but I wouldn't necessarily disagree. I mean, I think they also had to be qualified. Like, for example, Mr. Hart never really demonstrated as to why Ms. Lonneville was not fit to be the parent of the child. He never pointed anything to suggest that she was neglecting or abusing him. He also had no reason to believe. He even testified that he had no reason to believe that that the child's needs were not being adequately addressed. He was not aware of
Wait a
any.
second, didn't the child there, you have two kids, two adults living in a camper, no bedroom, no bathroom, using electric heaters. I mean,
Ms. Lonneville,
and the child had to wear a diaper, correct? If
that
he
is
had
correct.
the bathroom.
But I don't think that was a permanent state of affairs for them. I mean, the CPS had been to the camper and they never found anything wrong with it. So I agree that may not be the best possible housing for the child, but at the same time, it is unnecessarily.
Well, they made it seem, I believe, that they were using the grandma's house, perhaps, and
Yes.
they weren't really staying there. I mean, so,
They did have access to the
but I think
facilities.
the child said they stayed in the camper.
Right, but the thing is, they still had access to the grandparents' house
Mr. Greenberg, let me ask you this. The mother was talking about she was saving money so she could buy a place.
Right.
This camper, look, when I first read this case, like, this seems very odd that custody is going to go to the father in Kentucky when he's on the road 4 days a week, and the child's going to be staying with his new wife who's never met the child. And there's no reason why the father really can't live where the child lives. He says he went for money. He went up maybe $14,000 at most in the salary after taxes. That's worth it to move 6 states away from your child. That didn't make any sense. So it seemed, I was with you for a while until we get to this information about the camper and the boyfriend. And then the judge's decision makes a little more sense. But my question is, your client has talked about she's saving money. She's going to get out of that camper.
Right.
And she had all this money. Is she still in the camper now?
I don't believe so. No, I think she's moved on. I mean, I haven't heard from her in a while, but I don't believe she's in the camper anymore. I think that was just
Is she with the boyfriend who the child is afraid of?
That I'm fairly certain that he's still with her, but I haven't heard from her in a while to verify that either.
Yeah, because it seemed like her two impediments to custody are the boyfriend and the camper, and she could shed both of those and would have a lot better shot with her kid. But just like the father chose to go to Kentucky for his own reasons, she chose to be in the camper with this guy for her own reasons, and here we are. But
right,
I'm not sure, you haven't been in touch with her, so but that would be more for if she wants to move to modified custody. I guess she could do that if she's got a better living arrangements.
Well, I do know that I think that there is some kind of down in Kentucky. I believe that there was some kind of litigation going on there. She did mention last time I spoke to her via email, I should say. She did mention that there was some kind of order of protection going into place that she was opposing, but she did. I think it was more against family members from her, if memory serves. But I think relating back to Justice Nowak's initial question, that he's now making 5 times as much in Kentucky as he made in New York State. I mean, even if we were to assume that was correct, I mean, because I don't recall seeing any kind of financial statements to back up that claim. But even if we were to assume that was correct, he still moved 5 states over for his reason.
But he said my understanding of his testimony was that he was making 82 to 86 in New York. It's probably 86, right? People say 82 to 86, probably 86.
Right.
And he's making 100 down there. You're moving 6 states away from your child for 14,000? Makes no sense.
14.
But as I said, 14,000 before taxes. But you would acknowledge that this camper situation is not ideal. The boyfriend apparently is not ideal situation. The child has to wear diapers, just as Kane had said, and walk through the night to go inside through the snow. We're really looking at, I'm sure both parents are very good and they love their child, but we're looking at the least bad situation here for the child. And it seems like the father moving to another state where the child's going to be with a woman he's never met is less bad than living in that camper.
Right, but assuming that the camper is still an issue for them. So I mean, what I can do is I can, I can send her an email whether that's still the case and apply for a post submission as to whether or not the camper is still in place, or perhaps after me, I believe that the law guardian or the attorney for the child could more fully address that one, but getting back to the legality of it, Your Honor, but remember that the burden is ultimately on Mr. Hart to prove that it's in the best interest of the child for the relocation. And that's what, even if the facts remain as they are, that she's still living in the camper, she still has the boyfriend, and that he's making more money in Kentucky, why is this in the child's best interest to move though? And that's why I think that, is that, especially since the child was with Ms. Lonneville for most of his life going into this. And that's why one of the concerns is that, one of the factors in Tropea is you really want to interrupt a custody arrangement that had been in place for a very long time. So that's another thing that I think would weigh in her favor. In the end, did Mr. Hart prove that Ms. Lonneville was truly unfit to continue in the custodial parents? So,
Anything further?
no, unless the court had any other questions.
Thank you.
You're welcome.
May it please the court, Kelly Chacon for the child, Alexander. I'm going to rest on my brief. I think the court has a very good feel for the points that I raised. But I would like to address the issue of change of circumstances, because I don't necessarily agree that this is purely a relocation case. This court held in Rodriguez versus Young just last year that when a custodial parent seeks to relocate with a child, there's no requirement that a change of circumstances be found. I know this may seem contradictory, but I'm going to get there to my position. In this case, it was the non-custodial parent that sought the change of custody, and it seems that the change of circumstances may have been required. I think this court runs the risk of making a decision that, based on what the family court held and what I've actually submitted in my brief, that is inconsistent and would hold ultimately that even a non-custodial parent could relocate, change custody without a change of circumstances. So what I would like to submit in my oral argument is the fact that there is a change of circumstances. There are plenty of circumstances that are different, including the mother's withholding the child for 6 months or more, I believe, from the father, which, according to, which is the case? Fowler versus Rothman is the last case where this court has held that that conduct is so inimical to the best interest of the child that it raises per se a strong probability that that interfering parent is unfit. I don't think any unfitness holding has ever been held against mom. So that's number one. Number two, the changes in the father's residence, which I did want to address that point. Father's parents apparently live in Florida. And I guess I just wanted to draw the kind of distinction and point up the difference between mom's way of life and dad's way of life, where he's going to Florida and he's taking care of his parents. He is a trucker, and so he's driving there anyway. But he's showing this child the example of caring for members of his family by doing that. Whereas mom, on her side,
But then he moved to Kentucky where he has no family, and
No, he does have family. His own family lives in Kentucky.
he married somebody from Kentucky.
No, I believe she was from Connecticut. I believe that, I could be wrong about that, Your Honor, but I believe
His father lives in Florida.
his father lives in Florida. His mother lives in Kentucky, and his sister lives in Kentucky. And so he had a broader support system in Kentucky. And I believe the new wife was from Connecticut, and she moved to Kentucky with her 2 daughters with him.
His own child is not in Kentucky, is 6 states away. But
no, but so it put him midpoint is my only point. It put him midpoint.
That as it may, let me ask you this: there was an AFC below.
Correct.
Did not take a position. The judge did not ask the AFC to take a position.
Correct.
What's your view on that? Isn't that the role of the AFC? Why do we have AFCs if they're not?
Absolutely. Yeah, it was very difficult to glean from the record what the AFC's position was.
Is that not an obligation of the AFC?
Absolutely it is. Yeah,
And-
to find out what
and
the child
court-
wants.
And the court to ascertain the AFC's position?
Correct.
And then none of that happened here.
It's hard to tell is the answer that I can give you. I mean, I do believe that the AFC below, I did speak with him briefly. I do believe that he felt that it was in the best interest of the child to go with.
You know what's going on in Kentucky right now?
The child's in school. That's the only thing that I know. I did reach out to Dad for an update just last week because I knew I'd be here today, but I did not receive any response from him.
And there's no court proceedings in Kentucky.
I believe there are, well, so what Mr. Greenberg was referring to, I believe was a proceeding last year where mom's mom and dad filed a petition for visitation with the child so that they could see him at some point. And there was actually, this is interesting, there was actually a superseding order to which mom agreed that they would have 2 weeks of vacation in the summer prior to her 5 weeks in the summer. But again, I don't even know if those summer visits are taking place. My client, I will tell you, is terrified of mom's fiance, boyfriend, and does not want to go back there.
Is he still in the picture?
I don't know that.
Do we know if she's still in the camper?
I do not know that either. And Mr. Greenberg would know
All right.
better than me.
Well, we appreciate your advocacy.
Thank you.
Okay, 646, matter of Omariana A. Omariana A. Everybody is virtual for this argument.
Good morning.
Good morning. We have 2 out of the 3 attorneys. Mr. Jarzembek is, we are waiting for him to join us.
Good
And
morning.
he is here.
Okay, yeah, my video was not working.
No problem. You may proceed.
Okay, good morning. May it please the court. I am representing the appellant, Omar Atkins, the father of the child. I'll basically address the couple points in my argument, and I'm obviously open to questioning from the court. This relates to a violation of a suspended judgment that the department filed a revocation petition. It's our initial argument that we don't believe that the county showed enough evidence to sustain that. There were issues relating to 3 matters that were raised in that hearing. One related to to my client's employment status. My client testified that almost immediately after that a suspended judgment was ordered that he was injured at his place of employment, and that caused him a lot of problems in his life. Specifically, he applied for unemployment. I don't know if he applied for workman's comp because if he was injured at the workplace, that may have been another issue. I don't know if my client knew the difference. And that caused some issues financially with him in terms of his apartment that led to a filing of initially in, I believe, January, an action to have him evicted, but that didn't lead to an actual eviction. It led to actually a judgment that was granted against him in Buffalo City Court, I believe, in February of 2023. And then my client testified that he had some concerns about the apartment as well, even though he was living there. And that subsequently there was another revocation, I guess, that may have been filed in August of 2023. My client then, through not much assistance from the county, he was trying to get some housing, and the county has an obligation to provide him with housing. As the record indicates, my client is not a person that has had his children's rights terminated. He has over 10 children. He has not lost his parental rights on any of his other.
Right. So he got a suspended judgment in December of 2022, and he was supposed to abide by the plan for services.
Correct.
He gets evicted. He lives in a homeless shelter for a piece of time. He doesn't advise the caseworker of his homeless status or his new residence, so to speak. He misses some visitation with the child. Test positives for, I think it was Oxycontin.
Right.
And there's these other violations that the county's relying on that he failed to comply with the plan for services. Because as you know, a suspended judgment is giving you a second chance. They proved, and here we're going to put you on probation, so to speak, and yet one after another, the problems continued in the county's view.
I understand that's the county's position. He had engaged himself with drug treatment classes throughout the period of the suspended judgment. And I believe he had testified that he had had a last class scheduled in September of 2023. He also obtained housing on Condon Street in the city of Buffalo. I believe it's in the Riverside Black Rock area. And he is and he has been in a lot of communication with me. He still resides at that apartment on Condon. So he has had a history he's got a history of stable housing. This is a case also where, interestingly, in the middle of the litigation between the granting of the suspended judgment and the revocation petition, that my client asked for more visitation. And Judge Brinkworth actually granted him visitation. So he clearly with his child. And unfortunately, as I noted in the record, this case came into family court in the time of the COVID epidemic.
Sure, I think that was one of the reasons why the judge granted the suspended judgment, was to give your client an opportunity to really prove himself, and that he was able to maintain employment, stable housing, and be drug-free. I mean, that was one of the reasons. She, I believe it was a she judge, gave your client an opportunity to really prove himself. And he failed on those three things. I think she had more reasons, but she didn't rely on those other reasons in her decision.
Well, respectfully, I know that she did grant him additional visitation because obviously, I mean, I don't know why, but she did. So I would think that she thought that the visitation was going well. I mean, the county wanted it to be supervised visitation, and over their motion and in light of her, my client's trial counsel asked for more visitation, the judge granted him more visitation. I think this is a sad case. We have a situation where I believe, respectfully, that my client was in substantial compliance, perhaps, of the suspended judgment, and that this is one of those unique cases where the trial court has some discretion to actually extend a suspended judgment. I think that was, in this case, warranted. It's an unusual situation, and I would ask respectfully that the court consider remitting the case for or granting an extension of the suspended judgment. You know, ironically, my client is still even paying child support on this child, and we have a termination action. We have a client that's still paying child support. We have a client that doesn't have his rights terminated on any of his other children, and ironically, the mother ends up with the best of situations. She ends up getting she's got visitation, and you know, she gets 4 times a year with this child. And my client, who was raising this child because of mom's initial issues, is being penalized the worst of all. And I don't think it's good for the child. It's also, as I did indicate in my last argument, it's a little bit, you know, out there that, you know, there are some rights here of half siblings, and that is also another issue. But
well, some of the half siblings are incarcerated now for attempting to murder their cousin. They had weapons and so forth, and that was a concern of the county, that the subject child here is being in that environment. But look, your client did raise 10 other children. They're adults now, most of them, it sounds like, and he loves this child. On the other hand, the child has been in foster care, I think, since birth. And seems like a great situation for the child, wants permanency in the life. And so there's that side of it too. So these are always very tough cases, because I understand your client's parental rights and his love for his child, but then there's other considerations as well. So we will have to balance all of those here today.
If the court has any further questions, otherwise I'll rest on my brief at this point.
Thank you.
Thank you very much for your time.
Thank you.
Good morning.
Miss Counselor Fedusky?
Thank you. I apologize. Good morning, and may it please the court. Sam Fedusky for the Erie County Department of Social Services. It does sound like the court is very familiar with this case, so unless there are any questions, I would just rest on my brief.
Mr. Fox, you're the AFC.
Thank you, Your Honor. May it please the court, Russell Fox, Legal Aid Bureau of Buffalo, attorney for the child. Picking up on Justice Lindley's point, our client was 3 days old when she went into foster care. She's been in the same foster home ever since. She's now entered first grade. I can update the court as to how well she is doing if the court wishes. The only point I would want to make about our brief is that the final point asks for dismissal based on an inadequate record. After briefs were filed, counsel, as a result of a belated motion to settle the record, we stipulated to a supplemental record. So I would be withdrawing the request to dismiss based on an inadequate record. I'd be asking the court to reach the merits here, which I think are very clear. Thank you.
How's the child doing?
Really well. She's in cheerleading. She's, as I mentioned, she's entered first grade. She goes on camping trips with this family. She's, we saw her last, the trial attorney on this case saw her last month. She's clearly, in his estimation, bonded into this loving family, and we would ask that she be accorded permanency. Thank you.
Does the family wishes to adopt her?
That's correct, Your Honor. It's a pre-adoptive family.
She wants to be adopted?
That's right, yes.
The adoption can't take place when there's a suspended judgment in effect? Is that fair to say?
That's as a matter of law, the adoption can't take place while the parent still retains some rights. And so that's what's been delaying matters in our perspective for our client.
Thank you, Mr. Fox.
Thank you.
We will call now case number 650, Shanhals versus Morton. 650. Good morning, Ms. Const. I believe you are alone today. Mr. Berger has submitted.
I am. I will keep things brief. I'd just like to highlight that Judge Reed failed to conduct a proper analysis of the complexity of the matter, and my client was doing this from California without counsel. So the biggest issue was that he was, pro se doing this by himself and wasn't allowed to provide all the evidence about the disputes that were going on about the fees.
He had a lawyer from California, correct?
He had a lawyer from California who was either unable or unwilling to participate in the New York.
In New York, but he had a lawyer who was advising him to go to, because this is, as I understand your brief, Mr. Berger's motion was to withdraw.
Yep.
And to settle the fees.
Settle the fees.
You're not disputing the withdrawal portion of the order, right?
No, at that point, neither one of them. Berger had not been responding, wasn't giving him information that he was asking for. There were documents about the settlement. He wasn't telling him what they were discussing.
So that part of the motion is moot.
Yep.
Your client is fine with moving on to another lawyer.
Correct.
We're just talking about how much the balance is owed, and it sounds like it was $10,583 that was outstanding. That's what we're fighting over here, right?
Yeah.
And your position was that Judge Reed should have granted an adjournment so that your client could have retained new counsel, come in and dispute Mr. Berger's fees, a lot of which he's already paid, but this balance of $10,500. Well, so that's what you would want us to remit it then?
Yeah.
Vacate part of the order, allow your client to hire somebody, probably pay more than $10,000 to go fight over this with Mr. Berger?
I mean, if you look at the total amount that he's paid, it's $86,000, which is like 3 times what the hourly billable rate was. So it could come out that he's overpaid astronomically because the contingent fee was not fair to him to begin with.
So you want to go back and litigate the fees already paid?
I think that's what he wants, is he wants to litigate back. I mean, he's paid all this money, but
isn't there an avenue for a fee dispute outside of us remitting this here?
Yeah, he probably could file
through the bar association. All right, so we understand your point is that Judge Regis should have granted an adjournment when the motion came in.
Given him time got an attorney, let him hash this out, and then it would have been a more solid record. They had one appearance. He was on the phone because there wasn't a person in the room. If you read the appearance, there's lots of inaudibles in there because he's on the phone from California. He didn't really know what was going on, even though he had, in the heat of the moment, you might have counsel telling you, what's going on. But then when you're sitting there talking to a judge as a lay person, you don't really know what you're allowed to do and provide the information, because he was claiming that he was up to date. Berger was claiming that he wasn't paying anything. There was all sorts of disputes. There was times where he had gotten a bill and then he said, I'm not paying this. This is overcharged. And they'd actually readjusted it. So there were times that he had been overcharged that they had readjusted it. So there was a lot of information that having counsel could have helped clarify and not put him in this situation. So the easiest step would have been give him the 90 days to get him a new attorney in New York.
He did have a lot of time before, when the motion was filed. By the time it was heard, he had a lot of time there to go get a lawyer and do whatever he had to do.
But being in California, I think there was issues with, finding someone here and trying to work it out. And unless there's any other questions.
That's fine.
I'll rest on my brief. Thank you.
All right, thank you. Case number 652 is Rigio versus Belchure, 652.
Morning.
Good morning, Mr. Brown.
Yes, I'm here for the plaintiff appellant Russell Rigio. This incident that gives rise to the litigation was a house party that was being held by defendant Kaczmarek.
Is it your claim that he shouldn't have turned away in the moment?
My claim is that he set up the occasion for this to occur because I'm not saying he deputized Belchure, the one person who he said he knew was drinking that night. After the sofa was tipped over inadvertently by my client, he righted the sofa in the living room. And then either Belchure or Kaczmarek, it's not clear who, summoned my client to the back bedroom. Okay. So now Kaczmarek is behind my client. The door is behind Kaczmarek. Rigio, my client's there. Belchure's there. Okay. Now, it's our position that the lower court erred in this situation by granting summary judgment to Kaczmarek because there was an escalating situation that went on for 5 to 10 minutes after the couch incident, if you will, where Belchure said that I'm going to teach you a lesson, I'm going to punch you, whatever, all in the presence of Kaczmarek. In other words, it's not like some of the other cases we've seen, Crowning Shield cited by the respondent, that the host didn't really have any idea that an assault was about to occur. Here, and I would say it's distinguishable because, yes, we're not saying there's any prior incidents. We're not saying Kaczmarek knew that Belchure was violent or aggressive, but we're saying in real time, there's a duty here for Kaczmarek to safeguard the well-being
Right.
of
This is
Rigio.
like the Pink case,
Right.
where it escalated. The difference is in Pink, there were no security guards there to intervene in time. Here, you're saying Zachary could have stepped in and done something to prevent this because he was there for the 5-10 minutes. What do you think he did intervene and he got between them.
Yeah.
He did, what else should Zachary have done in this situation to, in your view, prevent, because at that point he knew they were arguing, but he didn't know who was going to punch whom, if anyone was going to punch anybody, right?
I suppose that's true, Your Honor, but the point is, if he wanted Rigio to leave the premises, Kaczmarek could have asked it's Kaczmarek's house. So if he wanted Rigio to leave the premises, he's in the living room at the time that's where the couch tipped over. Instead, he tells Belchure, tell him he better respect my property, something like that. And incredible as it may seem, it's Kaczmarek's position that nobody was drinking alcohol in his house that night. We had a bunch of 20, 21-year-old young men. And he says the only person who brings alcohol to the house is my client. Now, my client is very candid about his drinking. Yes, he drank a lot that night. It's in the record. But Kaczmarek says that no one was drinking in the house. No one had alcohol in the house. And that my client, who comes to the party 3 or 4 hours after it started, is the only one that brings a 12-pack. But I think it strains credulity, but they're saying they're playing water pong.
Playing water pong. I mean, I'm not sure that's ever been played ever in the history of pong. Water pong.
So what my point is, there's definitely credibility issues here as to Kaczmarek's truthfulness and as to what he could have done, Judge, going back to your question, like in the bedroom. Number one, there was no reason to summon Rigio back to the bedroom. Could have showed him out the living room, right where the sofa is located. But he has Belchure confront him, and then they're arguing. The argument continues back in the room. Now you're in an enclosed space, just the three of them. And I know that he says, he puts his arm out, Kaczmarek, well, okay, guys, but it's really escalating. And he puts his arm out momentarily. Everyone thinks it's done, and boom, Belchure lets my client have it, breaks his jaw, leads to 2 surgeries. But
your client, I think, said that Zachary stood between him and put his arm between him and tried to de-escalate. That was your client's testimony.
That's true. That's right. It's the testimony of all 3 of them, actually.
Yeah, so that's undisputed. So then your client turns to leave, and then he gets hit from behind.
Yeah, so
he calls a sucker punch.
Right,
that was totally unexpected by your client. But yet your client suggests that Zachary should have, it was foreseeable for Zachary, although not for your client.
Well,
your client didn't fear Dylan enough at that point. He was comfortable enough to walk away from him.
Or turned, at least.
Without looking, head towards the door. But no, I get your point. Look, this is not a spontaneous fight out of nowhere. This is a simmering dispute over 5 to 10 minutes. And so you not unreasonably argue Zachary could have taken some more steps to prevent this. And so it's a little different than cases that the defendants rely on. Is it enough? I don't know, but I get your point.
Right. It's just that I think the very act of having Belchure talk to him, what does Belchure care about a tipped over sofa? But he has Belchure say, hey, tell him to respect my property. And then either Belchure or Kaczmarek summoned my client back to the bedroom where the 3 of them are enclosed, as opposed to being out in the general party in the living room where all the other young men are located. So I think he said, sorry.
Is this different than the foreseeability issue that was identified by Justice Lindley in the pink dissent?
Right.
I appreciate that reference.
Yes, I wanted to make sure I got the
lunch tonight.
But in that case, they're talking about the hockey arena and the duty to. There's a duty issue, there's foreseeability, and here you're talking about a house party, basically. Not basically, that's what it is.
It is a house party,
right? And so, are we now going to say that you have to be on guard for your guests not to make sure there's a fight there, or the minute you see it, you're liable because you didn't step in and.
Well, I think in Crowning Shield, there's a difference where the host is not on notice of any aggressive behavior or words exchanged between the defendant assailant and the victim. And she's talking, way I read the case, she's talking to someone else, and there's not even an exchange of 4-letter words, and all of a sudden there's a punch thrown and there's an injury. So I think there, the host is in a different situation than Kaczmarek is in this case, because I would say he actually set up the occasion for the assault to occur by having Rigio drawn into a back bedroom where the 3 of them are by themselves. And I think that was careless on Kaczmarek's part. And I think it's a jury question. I agree with you. Both judges have pointed this out. He did do something. I think it's a jury question whether he did enough under the circumstances.
Is it relevant that the homeowner here, Zachary, didn't invite your client? Do I have that right? He didn't invite one of the 2 to the party. One of them just showed up.
Right. There was a couple of people who are uninvited, and
I think your client.
He was one of them. Yes, I agree. He was uninvited, but when he
showed up, does that matter that your client showed up on his own sua sponte, so to speak?
I don't think it matters.
It doesn't matter.
I don't believe it does.
Because once he's there, there's a duty, even if he wasn't invited.
Yes.
Okay, that makes
And,
sense.
and they knew each other from youth
I was gonna say
hockey.
they knew each other from
Yeah,
youth hockey.
for youth hockey, they knew each other. So there was a recognition that he,
Sure knew your client.
Belchure also knew my client, but Mr. Kazmarek knew him from youth hockey. And I think that and the other issue in the case is Belchure at the time was 20 years old. He was not of legal drinking age. And Kazmarek knew he had been out drinking. He admits that Kazmarek was drinking before he showed up at his house. And I think it's incredible to think that there was no alcohol in the house before my client showed up, 3 hours later and they're playing water pong the entire time.
So Belchure was a defendant, I assume he's the primary wrongdoer here.
Well, he's the assailant,
But
yes.
right, so but I guess for damages, you need that the homeowner's policy. Is that why we're here?
Well, to be candid, yes, but I think there's a good legal reason, but I think there's a good legal rationale.
No, I'm not saying anything other than I was just curious as to where we were with Mr. Belchure. He pled to harassment and
Yes,
he's still in this case as a defendant?
yes.
Okay, thank you very much.
Thank you, Judge. Thank you.
Morning, Your Honors. Jill Allen, may it please the court. I represent Zachary Kazmarek. I think that the court has kind of touched on some of my position here, our issues. Mainly that this was a sucker punch, self-proclaimed sucker punch by the plaintiff. And the plaintiff, right before the sucker punch happened, says that Zach steps between them. He thinks Zach has it under control. He starts to leave the room. He doesn't think that Dylan is going to do anything despite whatever their argument was, the words that were exchanged. He does not think that Dylan's going to do anything. So he starts to walk out of the room and then he sucker punched. But yet, as Justice Lindsay said, somehow Zach was supposed to anticipate it, but plaintiff wasn't.
So this was not foreseeable.
Was not foreseeable.
But counsel would say, maybe you're right, but the jury should determine this issue of foreseeability, not us as a matter of law. What do you say to that?
Yes, Your Honor, but the case law says about duty. Duty stems from awareness. That's the determinative factor. Basically, plaintiff appellant skips over the awareness factor. There is no awareness. The awareness, a prior awareness of that an incident like this is going to occur. He talks about mostly about notice in the moment. That's not what the law says. The law says that there has to be prior awareness that a situation like this is going to occur based on anything that happened with Dylan beforehand, whether he's gotten in fights, whether he's been argumentative, whether he had criminal activity. None of that happened. If anything, Dylan Belchure is a pretty good kid. Otherwise, that's how my clients described him. This was very out of character for him to do this. In one thing I want to point out in terms of plaintiff appellant's argument just now is he kind of says almost he furnished the occasion, not to use a labor law term, but furnished the occasion for this to happen. That's not actually true. Zachary went to Dylan and said, hey, can you get Dee and your friends to leave because plaintiff tipped over the couch? Plaintiff was intoxicated. There's no question about it. He starts tipping over furniture at his house. So he says, hey, can you go and ask Dee to get his friends out of here because he's starting to ruin furniture at my house. Mr. Belchure, Dylan says, let me go talk to him first. Dylan's the one who suggested that he talked to him in the back, or he didn't say the back bedroom. He said, let me talk to him first before we ask anyone to leave. That led to the conversation.
Part of the claim is this, the problem number one is this deference to Dylan, letting Dylan decide where and how this is going to be worked out. And I appreciate that, you talk about, we didn't have evidence beforehand, but you could come up with a hypothetical where you don't have any evidence beforehand, but boy, the way this thing is escalated, not suggesting it happened in this case. I mean, both your client as well as the plaintiff testified, I didn't think anything was going to happen. That's why the plaintiff walked away, turned his back and walked away, is because he didn't think he was going to get hit. So that and your client essentially says the same thing, despite the fact that the defendant said that there were threats to hit him during the 5 to 10 minutes. What about the plaintiff's argument, though, that they're in this part of the house, they're down at the end of the hall in the bedroom? I think your client testified it was just as he was stepping out of the bedroom is when he got hit, that that your client didn't protect him better by at least being in an open area as opposed to being in this confined area that essentially it sounds like Dylan picked out.
I would say that, I don't think if you're going to want to have a conversation with someone, I don't think it's unreasonable to pull someone aside and have a conversation with them, whatever it would be, if it's, a positive conversation or a negative conversation, I don't think that's unreasonable just to pull him away from the party to have a conversation about his behavior. I mean, if anything, it's less embarrassing to basically call out the kid for being too intoxicated or so intoxicated that he's tipping over furniture. You pull him aside and say, hey, clean up your act, and let's go back to having, our get together as we were having, because there were no issues prior to then, so I don't think that that's really, a relevant factor in terms of protecting him or not. No one, it didn't seem that just by Dylan pulling the plaintiff aside to have this conversation, that was going to then somehow lead to an incident between them. And again, as Your Honor just pointed out, even when they were having the conversation in this private area, the plaintiff himself didn't think that he was going to get struck until he was at the last second. So, I don't know, Justice Lindy said, what else could have Mr. Kaczmarek done? Eject one of the two of them would have been, I guess, the only answer. And if the factors for having
but that's hindsight. You're looking at something that's foreseeable here.
Right. And Your Honor, that's kind of my point, and kind of to go to that Pink case that, that's where the Court of Appeal said, like, what more could there have been done but to eject one of them? And at that point, who should have been ejected? The one who's intoxicated and not his friend and shows up at his house, unannounced, whether they knew each other from youth hockey or not, or the one who was his friend who was invited.
It may have been more reason to believe that harm would come from the plaintiff to Mr. Belchure. Might have, if you're a homeowner, maybe there would have been concern there that there was going to be some violence inflicted by the plaintiff. Who knows? I don't know any of these two gentlemen. I'm not suggesting anything, but it was totally unprovoked, totally unnecessary. And there were criminal charges and there's civil charges there. It's just a question, does the homeowner, is he on the hook for that? It's an interesting issue that we're going to have to resolve here shortly.
All right.
Thank you.
Thank you, Your Honor.
Case 653. Scott Zardic versus Scott Zardic. Good morning.
Good morning, Your Honors. May it please the Court, R.J. Freeman on behalf of the appellant, Michael Skatarzik. Your Honors, divorce law is often contract law, and we live in a world where we resolve our divorces with settlement agreements. Those agreements, whether they be oral or written, are very specifically incorporated but not merged into the judgment of divorce so that it survives as a separate contract to which the parties are bound. In this matter, we have a 2023 agreement of the parties, which specifically stipulated to a time frame of 30 days to make attorney fee applications. The underlying fee application that was made in this matter was made 37 days after that agreement and is time barred by the express language in the parties' contract. The court, as much as it may want to, cannot modify that contract, even if it reflects its notions of fairness and equity. Doing so by Justice Furlong was an error. Doing so would be contrary to the express terms of the agreement, the divorce contract itself.
Did the agreement say that no extension shall be granted, or that the parties were waiving their rights under the domestic relations law to seek an award of the fees separate and apart from the agreement?
Well, Your Honor, I would say on the idea of the domestic relations law, sections 237, if the parties' agreement lays out the basis for the application of the attorney fees, then the agreement between the parties controls and not the domestic relations law itself, that section. The parties stipulate to the terms that then control the application.
Yeah, you may be right. There's a third department case that goes the other way. I'm not sure if this is in the briefs, but third department case from 2022, it says, although it is true that where the parties have agreed to provisions in settlement agreements that govern the award of counsel fees, the agreement's provisions rather than statutory provisions control, the party may seek recovery of fees under both the statute and the agreement unless the agreement contains an express waiver of the right to apply under the statute. That's what that case says. we don't have to follow it.
Right.
But that seems to be similar situation here.
There's a second department case, I think it's a Bado, that says it specifically that if there is express terms within the agreement itself, then that lays out the basis for the application of attorney fees and nothing more.
Right. So your position is this is a strict 30 days, no matter what, one party could be in the hospital, could have been an emergency, no exceptions to the 30-day under any circumstances, not even for good cause.
I could imagine a world where an application was made before the 30 days based on that, Your Honor, but not after. No, I believe the 30 days is the 30 days, and law office error doesn't even apply. I think law office error could apply to certain parts of the CPLR, could apply to judicial laid out deadlines. But again, in this circumstance, the contract between the parties controls.
I mean, there's no requirement that say like time of the essence or anything like that. Like that would be a typical contract that will say 30 days is just a measurement. But if it doesn't say time of the essence, it's not strictly enforced.
No, Your Honor, again, I would disagree. I think that in this case, because there's express language within the agreement that says an application is to be made within 30 days, once that time frame has passed, the application cannot be made.
So you're saying it's more like an appeal than a contract, though?
Well, if
other contracts.
I think there are certain circumstances where this court would not accept certain applications if time had passed. Yes, for sure.
Can I just clarify something, make sure I understand what's at stake here?
Yes.
The parties put $20,000 in escrow from the funds from the marital house, right? They put $20,000 into escrow for fees.
That's correct.
So that's marital funds that came from the marital house, right?
Right.
So if there's no award of fees, then the wife gets 10 and the husband gets 10, right? It's not like the husband gets 20 or the wife gets 20.
That's correct. They get their money back, the money they put in.
10 to 10, right? The court here awarded 16,000 to the wife of the 20. I
think it's 12, Judge. Yes.
12, okay. So, but 10 of it, 12 of it. So 10 of it was hers anyways.
That's right.
So the award of fees here is just quite minimal.
No, because I think in this case, Your Honor, the fees were returned after the application was not made. And then a year later, then Justice Furlong made the decision after the fees had already been dispersed.
10 more. So
my client would, under the terms of the Judge Furlong's decision, would owe him like $12,000 of his own money out of pocket.
If it was a timely before the funds had been dispersed, 12 really wouldn't have been much at all. Because you're just giving her back her 10 plus 2.
No, I think at that point, then, under my understanding or recollection, the 10 of my client's money would have been paid out. The respondent would receive her money back.
Received her 10 plus the other 10 plus another 2 that would have to come from elsewhere.
Correct. The original contemplation was that both parties had the ability to make quantum merit applications. My client chose not to after the 30 days had passed.
You want to talk about the issue, the insufficiency of the application, net worth statement, all that stuff?
I do, yes.
By the timing of when you've got these didn't follow the uniform rules.
Right. I mean, as the court's aware, these issues only really need to be considered by the court if it deems the application timely. But in this circumstance also, there was in the application, there was a financial affidavit of the respondent missing and not provided to the court until after that issue had been raised, and then it was submitted.
When you say financial statement, is that net worth statement?
Net worth statement, yes, Your Honor.
And she submitted a net worth statement previously for the matrimonial.
Correct. There was one on.
Saying not an updated one.
Correct. Or not anyone at all, I would say. It was not attached to the application, which is a requirement.
The court had one, and the father had one, the husband had one of hers from earlier in this proceeding.
There were financial affidavits on file in this matter, yes, but they weren't, it was not attached to the application itself, which is a strict requirement.
Right. So, and if we were to agree with you on that, the remedy is to just remit it and have, it is not as though her application is denied outright and is gone, right?
There is case.
And it can be overlooked. These things can be overlooked. It's not like this 30-day you're talking about strict. This is not in that fashion.
I think this could actually even rise to the level of a law office error if it was raised appropriately, but there is case law that says that you get one shot at making a proper application and you can't remedy it after the fact. You can't remedy it in reply papers, and you can't remedy it in reply papers that are precluded from being considered by the court, which is also what happened here. Reply papers that were filed late, that the court deemed, well, Justice Hannah deemed that would not be accepted. It's very clear from the judge's decision, however, that he relied on those making the decision.
My understanding of the rules are that if a party fails to comply with the provisions of the uniform rules, which you have to submit, it's in the discretion of the judge to either draw an inference favorable to the adverse party or to deny the motion for fees without prejudice to be renewed. So that's all that was at stake here. If the court agreed with you, say, okay, you're right, the wife has to go back to the drawing board and she'll correct any deficiencies, and you're right there. It's not like it's going to be, it can be, the application can be denied with prejudice. Like this just seems all about nothing, the second point. Here.
I think there is, again, Your Honor, I understand your point. I think there is case law that says that the court can also choose just to deny the motion outright.
Okay, I will take a look at that. All right, anything further?
Nothing further. Thank you.
As stated in my brief, the application, well, there are two. My client is entitled to attorney's fees under the contract, also under the domestic relations law. She did submit the affidavit to the court and the motion for attorney's fees after a request for an extension was granted upon notice to opposing counsel. There is no prejudice to Mr. Freeman's client in the fact that the application was not received until 7 days after the 30 days had run. He certainly had ample time to respond and did so. His response was considered. The delay of 7 days did not cause any impact to Mr. Freeman's client. He could have retained the funds and so that they could then be distributed, but instead they were in fact distributed to the parties. And the court did find, Judge Furlong did find that on Mr. Freeman's request to re-argue this motion, that there was an independent right under the DRL to file for attorney's fees, and that even if it was not proper to have granted the extension, which he did think it was proper to do so, he said he would have done the same, but that if even separate from, as your honors are aware, from the contract, there is an independent right to make the application. And the circumstances were such that the court did grant the application.
Thank you very much.
Thank you.
Case number 655, Baldino versus McDonald. Good morning again.
I think we've
yes.
flown over into afternoon. If it pleases the court, Rebecca Const on behalf of the appellant. I'd like to start with that it was not an unreasonable request to have this gate over this right of way locked and closed. The property, the appellant bought the property with this gate and lock already installed. The gate was put up in the 1980s, between 1980 and 1988. They didn't know exactly when the gate was installed, to keep unauthorized personnel out of those subservient properties. So it's not unreasonable if this gate was installed to keep those properties protected for the landowner who is right there. If you look at the pictures, the gate is right next to her house, to have her request that the gate be locked and closed to protect her property as well.
But for years, she didn't do that, correct?
As soon as she bought the property, she was requesting that it be locked. I think there was a long period of time before she bought the property in 2015 that the gate, they did whatever they wanted. She had no idea how the gate was utilized then. But when she bought the property, the gate was closed and the gate was locked.
She bought it in May of 2015. She sent a letter in December of that year.
Yes.
So is that, I think Justice Greenwood's point is that for years before she even got there, it was customary to for the McDonald's and the other folks who had the easement right to open it up so their guests could come in. It's just, my understanding, it's a big hunting area, there's no cell phone, they invite guests, like, it's just not feasible to come back and unlock it for them.
I think
that's how it worked for years, and they say, look, there's been no vandalism at your client's property ever. There's no evidence of it really significant trespassing going on. So you balance that, really not a lot of harm to you, a lot of inconvenience to them and their guests. And the court balanced it. Is this a reasonable restriction? And the court said it's not reasonable to have this lock on there. And so we have to look at, is that determination consistent with the evidence here?
I think it's just interesting to point out that it's okay for them to have to lock it when they want to lock it, but it's not okay to have to lock it when they don't want to lock it. She's the only one who lives there full time, so she would get the most downside of if something was to happen. And there are, there were some letters with the DEC about poachers. She's had incidences of the ATVs almost driving into the side of her garage. So, and if you looked through the testimony, there were other, some of the landowners were saying that was their practice, is they would drive through, they drive up, open the gate, drive through, close the gate, and continue on. Mr. McDonald was the one who seemed to have the most issue with having to relock this gate, so he would start driving around it, which isn't staying in the easement.
The fact that that gate is not described in the easement document, correct?
Correct, because somebody added it after the fact. But when she bought the property, there was this gate with a lock on it. Apparently at one point back before the gate there was a piece of wire that they would, roll out and roll back.
The other people are the beneficiaries of the easement.
Correct. And they're the ones who put the gate up.
Do you think it'd be a reasonable restriction if your client were to demand advance notice and permission from her, the guests, to go through the gate? She had wanted that at one point.
She had wanted that at one point.
Reasonable. You would acknowledge that's not terribly.
I don't think that's terribly reasonable. But I think that their practice is, when they're protecting their own property, is to close and lock the gate.
Right, but look, it seems like that gate and the lock is not the only way to keep trespassers out. They just walk through the woods, right?
It's a large area. I think it's unfeasible to expect that you could barricade the whole thing.
Right.
Like, you can't fence it off.
And trespassers who aren't invited by anybody. It's not like that lock, if that gate is locked, or they're going to stay out. They're coming on.
But usually
the answer.
The easiest means, the easiest access is on that roadway. So yes, if somebody really wants to get there, they're going to get there anyways. But the most, the ease, most people are going to drive up the road, and, the ATVs, there's trails all over the place. The maps aren't really clear. People are going to stay on, they're pounded in them, stay on the trail. So the trail is where most people are going to go.
It would seem like this case was eminently settable when I was reading this transcript. With the technology now, with combinations and so forth to give to your guests, we don't need keys. People don't need keys anymore. Okay, this isn't 1980. This just seems like if everybody were I know we're probably beyond that now with the friction here.
Mm-hmm.
But there is a way to work this with the technology and that gate that could accommodate.
Put a different lock on, because there was all talking about how you had to get out and go around to the other side, and that was burdensome. There are locks that, correct.
But I think the McDonald's would probably say your client came on too strong, too fast with Inspector Harry and all that, and photographs and doing all that. And it's probably beyond that now, which is why we're at trial. So this is kind of irrelevant, but it's really, is it a reasonable restriction to require that lock? And that's what we have to look at here, right?
And the argument is that if it's unreasonable, then why is it okay when it's them that wants to do it? But not when she, the person who lives there year round, is asking for the same thing that they would do if they were going to leave and protect their property.
But they want it, so it's your argument that they want it locked when they're not there?
Correct. That's what they do when they leave the property, they close and they lock it. So it's okay to protect their property, but it's not okay for her to say, hey, I live here full time. Could you just make sure that when you go through it, it's locked for my protection? Because
So the
that's
only-
what they do when they.
The only problem is when they are there and they don't want to lock it because they have friends coming.
Correct, but there's
So-
ways around it. I mean, you get out, you walk around, you unlock the gate, you drive through. It's not like it means that they can't have friends who come through it. Somebody put a little key lock thing in there. There's a key like in there. So it's not like these people, you have a friend come, you explain how to do the gate. They do the same thing that they do when they, when the property owners get there. How is this unreasonable that you give your instructions to one of your friends that's going to come and use your property?
But isn't the problem you have that there's a Court of Appeals case that talks about the convenience to which they become accustomed in the easement, and they become accustomed to the gate not being locked.
When they first get to the property, they usually have already locked it. So how is that?
First get to, but then they're using it for a season or hunting season or.
I don't think it's they open it at the beginning of the season and they close it at the end of the season.
You're saying they only when they specifically use it.
That's what I'm getting from the transcripts.
But wasn't there an argument too? There's no cell phone service way back in the woods. And so like if they have a guest that appears, the gate's locked, they have a guest that they have no way of calling because cell phone service doesn't work.
I think there's.
So there's supposed to be a certain time, you better be there at 2:00 for me to open that gate.
But
and if you're not there.
In the, like, somebody put one of those like little kind of lock things. So there is a key in the gate. Somebody put that in there at some point. Like there's ways to have dealt with this situation. If you're having guests over, you explain to them how to deal with the gate. The local, they talked about the ambulance and first responders. There's ways to deal with that too. They're not the only people in the world who have gates on their property. If there's shoddy service, there's ways to have handled this. It doesn't seem unreasonable to request that it be locked when that's what they do when they're not there anyways.
From the diagram on page 400 of the record, it was plaintiff's exhibit 23 itself, because there's a sticker on it. It looks like your client's driveway. I see where your client's house is in regard to Fowler Road and also then the Woods Road. But it looks like your client's driveway is before the gate. But as you're coming up to the gate, you go into your client's driveway before.
And then they turn, and then it continues and then turns, I think, yes.
So if there's going to be people coming up your client's driveway, it doesn't matter whether the gate's locked or unlocked. They can still do that.
I think what it is they just continue on. Like, it's hard to tell from this picture and there's snow, where she said that they've had ATVs that have almost run into the side of a garage. So there must be an issue with the gate not being locked.
So these would be ATVs coming down Woods Road from the defendant's properties, heading on their way to Fowler Road. And then when they get through the gate, then they somehow turn into your client's property. And I'm getting it. Well, all right, we'll give it up.
I haven't been there, so I don't know.
Okay.
But if there's no further questions, I'll rest on my brief.
Thank you.
May it please the court. I'm Keith Coughlin from Schwartzman and Wise. I represent the respondents, John McDonald and Mr. and Mrs. Teal. Each party owns 2 great lots back in the woods in Lewis County. A great lot is a 200-acre rectangle of forest, logging roads, deer, game. And in each of these 400-acre parcels, my clients have a cabin they use on the weekends, sometimes for extended periods of time in other parts of the year, but generally on the weekends for their use. The camp is 1.5 miles, and then the Teals camp is 2 miles east of the gate, the Marmon Gate. The Marmon Gate is at the end of the public road, which is the Fowler Road. The Fowler Road continues due west into Ms. Baldo's driveway. To get to the Marmon Gate and then that 1.5 mile or 2 mile road to my client's camp, you have to make a hard 90-degree turn off of the Woods Road or the end of the Woods Road. It's essentially a T intersection. And Justice Nowak was getting at that the ATVs, and the trucks that run up the public road and then continue on into her driveway, and apparently rammed her garage at one point, according to her testimony, that unfortunate activity has nothing to do with the gate locked or unlocked.
They don't go through the gate.
They don't go through the gate. They don't go near the gate.
She could put up a gate in her driveway if she wanted to. Could she not?
If it were on the other side of the hard right-hand turn into the Woods Road, sure. She could. This gate was put up by Kim Teal's dad in 1988, Mr. Marmon. At the time, he was a member of a hunting camp of those two great lots that the Teals now own. The respondents have an easement for use of the Great Lot 227 on which Ms. Baldo's property is located, quote, for the sole purpose of ingress and egress on foot or with vehicles over said roadway. There's no other remarks about the roadway or the right-of-way. Not a reservation that you can't put a gate, not a reservation that it can be locked or closed, or a requirement that it be locked or closed. No width, no discussion otherwise of the scope other than for access. The appellant's parcel on Great Lot 227 is at this T intersection, and her predecessor in title, Mr. Fowler of the Fowler Road and of the Fowler Homestead, which you see in some of those photos. For instance, photo Exhibit 14 at 392 shows the little Fowler Homestead, and then the new cabin mansion that Ms. Baldo installed in 2016. Mr. Fowler conveyed a right-of-way to McDonald's predecessor in 1980. It's all laid out, in my view, in the photo. We refer to record 392. The supplemental record, page 1, trial exhibit 7, shows a survey of this area that shows the locations over time of the approach to the right-of-way, and specifically that T intersection, hard right-hand turn to get onto the Woods Road. The appellant purchased her parcel, as you all pointed out, in 2015 and commenced this lawsuit in 2016. Shortly after her purchase, she insisted that this gate, which had been erected in 1988, the practice of which for the users of the right-of-way and their guests was to, on their initial entry to their property, leave it open for the weekend. And as they left, they'd lock it up. They left it locked for the work week, essentially, because back in 88, there was some use, according to Mr. Marmon, by ATVs, by three-wheelers and four-wheelers. We got to a new era of ATVs, but back then it was the three-wheelers, and it stopped the problem. They continued the use of the gate and that practice of locking it as they left for the particular visit. And the purpose of leaving it open was for guests to come into the property, for emergency vehicles to have access if needed, because as Justice Keene pointed out, there's no self-service back in the woods, and it's just really inconvenient to try and work out a time. Okay, I'm going to show up there at 10. Please come unlock the gate.
What's the problem with as Justice Lindley indicated, coming into the 20th century and putting up a digital 4-digit lock that everyone knows
Judge, I don't think
satisfy the whole problem.
I don't think that's a problem, and unfortunately, it didn't satisfy the whole problem. What the test for this court is there a fair interpretation of the evidence, which goes.
I understand. It just seems that we're here, and it's unfortunate that it's come to this stage. And
it is.
Inspector Harry, or whoever it was, who was the individual who came through and made some assessment of this issue or problem. It just seems as though more reasonable minds would have taken care of this matter before. But proceed. I think we're very familiar with the facts and the time frame and the easement and
okay. So I was just going to go into a little bit more about that, but I'll skip over to the main point. Judge McCluskey's determinations were correct. They're supported by the evidence at trial. It should be affirmed. The judgment is warranted by the facts, and we refer this court to your prior affirmance of Judge McCluskey in a Jefferson County case, Myers versus Beal in 2023, which states the requirements for non-jury trial and the deference that should be owed to him. And the test is whether a fair interpretation of the evidence supports the court's conclusion. Well, it does. And also refer you to matter of Estates of Thomas, this court, 2019, same thing, that the deference to the trial court on credibility determinations and viewing everything in the light most favorable to sustaining the verdict. That's the short version. I have other facts from the reply that I could go into. I think you all have picked that up. So we'll just close that the judge Justice McCluskey properly determined that this was impractical and inconvenient for her to make these demands on my clients, the users and their guests. That impracticality and inconvenience is the tipping point under Grafton versus Moore and Lewis versus Allen. That is that her client has a limited right to gate, cover over, narrow a right of way, but it's limited by the convenience with which or to which the users have become accustomed. So John McDonald has used that right away since 1970 when he was in high school. Kim Teal used it since 1974 when she was a 14-year-old kid going to the hunting camp with her dad. And Mike Teal's used it since he married into the family and became a user of the property. So for all that time, the convenience was pretty convenient. They were able to go in, leave when they wanted to, close it up at the end. This requirement that they get out of their truck, lock it, go back in their truck and leave immediately after having gone through the gate is unnecessary, unreasonable, and the judge was proper in determining.
It's unreasonable when you weigh it against the prejudice to the other side, I think your point is. If they had a lot of people running through the yard and tearing up the grass and all sorts of problems with them shooters, then maybe our calculus would be a little bit different. But they don't seem to have significant evidence of any downside here.
Right.
To the gate being open. Minor problems with the gate being open compared to a little bit more than minor inconvenience. You think we should weigh it in your client's favor?
We do. I do. Thank you.
Thank you. Yep. His number 657 and 658 is HSBC Bank USA versus Dubia. We have Mr. Kraus is here substituting. He's virtual. And Mr. Carroll, you may proceed.
Okay, thank you. Yeah. HSBC Bank foreclosed this property using a foreclosure order, which at the time of the foreclosure was void, wasn't filed, and was a product and was void because the motion wasn't served. And it was also suspended by the court pending resolution of a hearing date for issue that occurred at the hearing that was unresolved at the time.
Counsel, just first, your use of the word void. I think in your brief, you were referring to, I think you used the word struck, but I think it might mean this.
One was, sorry, go ahead, Your Honor.
Well, I think what you're referring to is a notice that was drafted by the Oneida County Clerk or the clerk of the court advising the Oneida County Clerk's office to delete the uploaded document pending the oral argument on January 15th. Is that what you're referring to?
There's two grounds. That's one of them. That's the one of them. That order was struck by the judge because pending a new hearing and resolution that was caused by a date controversy where he missed the hearing. They never remedied that before the foreclosure. There is a second issue in which the notice of motion with the summary judgment, there is nothing in the record to indicate that my client was served with the document by mail the way he should have been. So those are the two grounds for the foreclosure order not being valid.
The motion, the judgment foreclosure was done in December. The motion of summary judgment was back in April, months before, which is typical in these foreclosure cases. I don't necessarily disagree with you regarding service of the motion of summary judgment, that there was a service problem there. The concern I have is that resulted in a default. Motion for summary judgment was then granted by default, probably maybe because your client wasn't served with it, whatever reason. It would seem to me, though, that under CPLR 5511, there has to be a motion to vacate that default. There was a motion to vacate the later default. And
with the hearing date scheduled.
But I don't see in the record any motion to vacate the first default. And so I don't know if we then have jurisdiction issue.
I didn't catch the second default you're referring to from the service until later in the case. And I said, well, it's jurisdictional. I can raise it at any time. So we'll put it in.
I see.
So just so I understand, and I'm not as well versed as you, Justice Nowak, on this, but the summary judgment motion was filed were returnable April 15th, 2019.
Yes,
right?
sir.
And you're saying, and your client did not respond to that. There's no opposition. And you're saying because he never got the motion?
Yes.
Did he put in an affidavit to that effect saying I never received this?
No, like I said, I caught the point a little later.
Don't we need an affidavit from him?
No, I believe it's their burden of proof to put in a proper affidavit that they served it by mail.
Okay. And you're saying they didn't do that. All right. So there was, and then we had the problem with the motion for the judgment of foreclosure and sale that came later. There was a return date of December 12th.
Yes.
2019. The court apparently moved it up a date without telling your client. Is that what happened?
No, the original hearing date, I think, was back in November. And the 12th, if I remember correctly, was the adjourn date for the problems with that hearing.
Right. But then
that got adjourned to January. January got adjourned to February. They didn't show up for another thing. It got adjourned again. My client files for bankruptcy. It all goes into limbo.
Your counsel, the other question I have is
then they foreclose.
In the record, you say that it got adjourned in February, and I appreciate that the record reflects that there were mandatory conferences scheduled in February. But they didn't refer to, the court didn't refer to the return date as a mandatory conference beforehand. They just referred to it as the new motion date, I think, is what the court referred to it as.
Yes.
The defense claims that when the new motion date was set for January 15th and there was no appearance on January 15th, the court considered it submitted and the motion was over. And that these February dates are just mandatory conferences. They're not, it's not an adjournment. I don't see anything in the record that reflects that the motion was adjourned. I appreciate that there were further court appearances down the road, but that happens in cases all the time. How do we know that the motion was adjourned?
Unfortunately, I didn't handle the case and I picked it up from the bar afterward. So I'm stuck with whatever the record says. And I don't have and my read of the record was that they adjourned it to January. And on one of these times, the defendants didn't show. And they adjourned it out again with an order, you better get in here or else. And then it went, and then my client filed for bankruptcy. So I'm not sure if there was a change like that in there or not. I wasn't there. And I don't have any way of getting it from Mr. Goldboss.
Any contentions relating to the order of summary judgment, any contentions that you're raising are unpreserved. You're raising them, but they weren't raised below. Is that fair to say?
That's fair to say on the fair to serve the notice.
So on the summary judgment.
Of summary judgment.
And so we had the only defense that I saw that came later was failure to comply with the CPLR with the mandatory conference, these settlement discussions that you're supposed to have. Right. That was, he didn't say I paid. He didn't say anything else. He just said, we need settlement conferences. Judge Groh had it back in 2018. He had conferences and he realized they weren't going to be fruitful. It was just a situation. He couldn't have your client couldn't afford a trial payment plan. So where are they going? So they did have conference. And then it results in, if my dates are right, your client stopped paying the mortgage in, he went 6 years. He stayed in the property 6 years without paying a penny until it was sold. Is that correct?
I'm not sure of the time period, but that's my general understanding of it.
It was sold on June 6, 2022, right, in foreclosure.
Yes.
And he hadn't made a payment since June of 2016, I believe.
I'm not exactly sure of the dates, but that's an accurate summary of the situation.
And if we were to, if we were to reverse, it's not like your client wins. Would he have a settlement conference and then he can oppose summary? I mean, where's it going?
Recommended him to sell the property and get his equity out of it. There was
somebody else already lives there now, right?
No, he lives there. He still lives there. I stayed the eviction down in New Hartford Town Court.
Okay, so he's there now 9 years without paying anything. 9 years with no payment. Is he paying the property taxes?
I haven't checked.
Probably 9 years without a penny for anything. This is a good country, America.
He had health problems.
Yeah.
That appeared.
Okay. Anything further?
That's the main argument. There's some other stuff like they used an ancient referee report, that type of thing. But those are the two main.
That wasn't preserved either, was it? Claim the referee's report was too old. That hasn't been preserved. That wasn't arguable, right? You weren't there, right?
I weren't there. I raised it and I don't see the transcripts or anything else, and they haven't said it wasn't.
All right.
So
Thank you.
I can't say one way or the other.
I appreciate it. Thank you, sir.
Let's hear from Mr. Cross. Thank you, Counsel.
Thank you, Your Honor.
May it please the court, Skylar Krause, Hinshaw and Culbertson LLP for the HSBC NA. Justice Nowak, Justice Lindley, you are correct in your time frames as well as in what's been preserved and what's not been preserved in the record. What I find, what I think needs to be amplified here is beyond everything that your honors have raised, is that Justice Clark really did bend over backwards. I mean, the borrower here had opportunities to be heard, despite not appearing or despite default, regardless of whether or not there was initial notice. The first notice that comes out after, with the court by the court clerk that talks about the order that was uploaded also adjourns the matter and adjourns it to January. No papers. Certainly the borrower knew, he did not put in any papers. After that, yes, it was adjourned. It was not clear that it was adjourned for further motion. I think it was adjourned for a conference, as Justice Lindley has pointed out. But beyond that, the reason that my client doesn't appear is because in the record, it shows the bankruptcy was filed on January 29th, before that February date. So yes, they didn't appear, but because they knew of a bankruptcy, and then the court—
There were two bankruptcies that were filed that were eventually dismissed.
Correct. And this was the first one. So anyway, the borrower had the opportunity at that point to put in papers to cure the notice issue or address the notice issue. Nothing happened. Instead, he files for bankruptcy. The case then proceeds after the bankruptcies. He gets another opportunity after service of the notice of sale. He then files an order to show cause. There's a hearing, there's a transcript, it's all in the record. He is given another opportunity to put in opposition to the MSJ. Judge Clark gives him the opportunity to make his case. He doesn't comply with the deadline of putting in opposition. He instead files opposition on the date that reply is actually due. Reply is then put in, but his opposition doesn't have anything to do with the merits, doesn't talk about, the only thing he complains about is not having had notice of that original MSJ that was filed. And that's just patently insufficient. And so Judge Clark was correct in ratifying the order that had previously been entered and in finding that my client was entitled to judgment of foreclosure and sale.
Thank you, Mr. Krause.
Thank you.
Last case is 659 Duncan versus Town of Greece.
Good morning, Your Honors, and may it please the court. Chris Borgatti here with Maxwell Murphy, attorneys for the appellant in this matter, Dylan and Duncan. So I feel like the best way to describe where we're at here is to give you an illustration. My client's driving at about 6:30 in the morning. He goes to an intersection. The light presenting him is green. Proceeds through the intersection. Another car hits him, turning left. They T-bone. At that point, my client and the other driver that was involved in the incident both stated to the police officer, who also confirmed with his own eyes that the light was dysfunctional. It was posing green in both directions. So
it had rotated, correct? It rotated 90 degrees?
It rotated 90 degrees, yes.
It wasn't like it stayed in place and someone went haywire with the lights. It was supposed to be stationary. There was a rod attached to the sign, and there was, more importantly, a little knob at the top that was supposed to keep it in place. the rod was broken, this didn't work, and it just turned.
Correct. Yes,
90
Your Honor.
degrees, right?
Yes.
Okay.
So it faced 90 degrees, it had twisted. So I think it's important to make sure that that the court is aware that in the preceding hours before this, remember this is November, it's early in the morning, it's a little dark. The lights were flashing, blinking yellow. So no one would have noticed it for hours until potentially in the morning, once it turned red and green. That's also in the record from the testimony of the defendant.
Is it undisputed that without that pipe connected to the sign, we know that pipe was broken? The what I think is called a hanger, a disconnect hanger at the top, that in and of itself is insufficient to keep the light straight so that it doesn't twist. That everybody agrees. Not only does your expert say that, but the county agrees as well that, yeah, that's not, and we know that because there's a pipe at the bottom, because otherwise you wouldn't need the pipe at the bottom. So we know that, right?
Correct. Yes.
And we don't know when the pipe was broken.
Correct.
We do know that the pipe was installed in 1990 and that it needed to be replaced in 2003 after 13 years.
Yes.
And after it was replaced, 13 years go by and then another 5 years go by. Now we're at 18 years, and that's when this incident happens.
Correct.
And the pipe had never been replaced during that interval.
Yes, Your Honor. And in fact, these pipes have been replaced at other places in the county as well. There's about 75% of the intersections in the county now use a new form, which is called a mast arm.
Yeah. In fact, your expert says that you shouldn't even use these pipes, even if you don't have a mast arm.
Correct.
About that you should use a tether, that the code requires a tether, not these pipes, that this is almost like a makeshift thing. That's your expert's claim.
Yes, Your Honor. He cites the New York State Department of Transportation, the direct detail chapter 680-07, chapter 71, title 8, article 44, section 1682, that tethering signals is necessary.
Tether, you mean the wire at the top and the one at the bottom, right? The two wires. My understanding, the expert said, because we had the wire at the top.
Yep.
Lights hanging. My understanding is the code requires another wire underneath.
Correct.
And that wasn't here.
That was not here.
And your expert says it's required. And so a lot was made about notice. And I think the motion court here said no actual notice. I think you would agree with that because the complaint came in just minutes before. Even if there's no constructive notice, this is, in your view, a creation case. They, by not properly installing it with the tether wire, the second wire, by not either using the mast if it was wide enough at the intersection, by hanging it too low. Apparently, according to your expert, if it was hit by a truck, which is the most reasonable explanation, there's no trucks that are more than 15 feet. This light had to be too low.
Correct.
So all of those, you say, those problems are not notice issues, those are creation issues, at least an issue of fact to get you to trial.
Well, 100%. And I think in addition to that, Your Honor, you have the complaint of negligent inspections. Many of these inspections were done from the ground, looking up. So you have to imagine this is 15 feet, allegedly 15 feet up in the air, without specifically inspecting each individual signal. There's no real understanding of when or how this broke.
So failure to inspect, can that be creation, or is that just goes to notice?
Well, so if you create it, you don't need notice. But what we're saying essentially is that they created this hazard by the fact that, number one, they didn't use the tether. They allowed it to persist. They have a continuing obligation under the law to maintain a reasonably safe roadway. And the failure to not inspect it when they were there just 5 days before as well, they should have had constructive. I think that's constructive notice.
When the installation was originally made, was it compliant with the current code in effect at the time? Is this an amended code or?
I'm sorry, I don't have the answer to that question.
No, okay. And then the second thing I want to ask you about on the motion court, that they granted it both pursuant to 3211 and 3212. Did the court give notice that they were considering it pursuant to 3212? I didn't notice that.
So this was a renewed motion. So right. This was initially brought by the defendant before discovery. We survived that initial motion to say, come, you have leave to bring it back after discovery. So the short answer is it was sort of accepted as a 3212. That wasn't something that that I was aware of. But it sort of combined itself into two joint motions.
The original motion was a 3211, wasn't it?
A7, yeah, failure to state a claim.
And there was no 3212. Then the court decided it as a 3212, but did the court ever send you notice, giving you the opportunity to?
That's a good question. I don't believe that's not something I can answer.
For both sides treat it like summary judgment.
Both sides did treat it. That's how I treated it.
Already, and yes. You submitted stuff. The expert, there's some talk about that clamp. I think there's the clamp above the light.
Yes.
The purpose of the clamp is to keep the light stationary so what happened here doesn't happen. It doesn't rotate. Your expert says if the clamp was properly installed, the pipe connection between the sign and the signal head would not have been necessary. So whether or not that pipe was broken, your expert says there was a defective clamp. The clamp didn't work. Because if the clamp was working, even without that pipe, the light wouldn't have switched and this accident wouldn't have occurred. That is a creation issue in your view.
I would say
that clamp wasn't installed properly, apparently.
I would say affirmatively that's a creation of the defect. Yes.
Now, on the summary judgment, the burden of proof is on the moving party here, the defendant.
Correct.
Hard to prove, like they didn't prove the width of this intersection for the 35 feet and all that. Once we get to trial, you got the burden of proof.
Correct.
But here, your point is they got to disprove all these allegations as a matter of law to meet their initial burden. If they by chance did that, then the question is, did you raise an issue of fact? I'm not even sure they met their initial burden on all these creations. There's a lot of creation issues. At trial, though, if we get there, you understand it's going to be, you're going to have to be the one. They just sit back and make you prove stuff.
Correct. But at this stage in the game, it's that's for down the road, essentially.
Anything further?
Yeah, I think, the lower court, and I don't know if this is something the court would like to address about the governmental immunity. I think that it's an important factor to discuss that it is also the defendant's responsibility here to demonstrate that the appellant's pleading here failed to state a cause of action in its proprietary capacity. I think it's plainly clear that maintenance of traffic signals is clearly within the realm of the ordinary negligence rules.
It's like the design of roadways and so forth.
It's not, this is the design of roadway.
Yeah, this is not design of roadways, but was a similar law applied to a negligent design?
Well, I think the design and there's a second layer to that. So inherently the decisions made by a governmental body, legislative body, it's presumed that they're made reasonably and with knowledge of the safety. So without, an adequate explanation or unreasonable rationale, those normally stand. So this is sort of a step further. There's an obligation to continue to make sure that the traffic signal intersection is conforming to state regulations and safe.
That might be a maintenance issue, and maintenance can go to creation as well. So
yes, I think clearly that the defendant hasn't produced any evidence or refuted many of our positions in our complaint, and our complaint simply pleads, failure to maintain, and that is quite frankly a directive at the proprietary capacity of the municipality. So it should be restored, and the complaint should be reinstated.
Thank you, Council.
Thank you.